So, good afternoon. Welcome to the latest in our series of lunchtime special interest webinars from Bristol Law Society. Today, we're going to be taking a look at business interruption insurance and the COVID-19 pandemic. Please note this webinar will be recorded and published, so please be aware that any questions you ask, or if you come off mute or post into the chat, may well be recorded. Dr. Ozlem Gurses is an academic at King's College London, where she teaches insurance and reinsurance law. She's a committee member of the BILA. She sits at the Presidential Council of the AIDA, and she's vice chair of the Reinsurance Working Party of the AIDA. Her slides from today will be sent out by email to those who have subscribed to attend. If you have any questions, please feel free to raise your hand virtually if you want to ask them as we go along. Alternatively, you can post them into the Q&A or the chat box, and hopefully there'll be time at the end and we can go through and answer any questions. So without any further ado, please, over to Dr. Ozlem Gurses.
Thanks very much, Leon, for the introduction. Let me first try to share the screen, and then I'll start my presentation. So I hope that you all can see the slides now. And I understand that the slides will be shared with the attendees later. But for now, so then please follow the screen. I'm not sure whether I will be able to see if anyone raises their hands for questions. So therefore, it might be sort of a best bet to also type the questions, just so that we won't miss your questions, just in case that I miss your hand. Okay, so I'm going to talk about business interruption insurance. I thought that before I talk about generally what business interruption insurance is about and some of the principles that have been already well established and how actually those well established rules can apply in the COVID-19 context, I wanted to refer to the FCA test case, which probably all of the attendees have heard about. That it's a test case of the validity of business interruption claims. And a little bit of history about this case is that the Financial Conduct Authority, after the coronavirus outbreak and the businesses have suffered huge losses, and the insurance matters, they appeared in the media more often than before. Then the Financial Conduct Authority then approached 56 insurers and reviewed over 500 relevant policies from 40 insurers who provided their wordings. And as a result of which, the Financial Conduct Authority identified a sample of 17 policy wordings. And I included here a link for that. Those of you, if you haven't read those policy wordings yet, here is the link for that. So then those identified policy wordings are going to be tested by the court, and the hearings are going to be between the 23rd and 30th of July this month, and the decision, we will see when that will be out. And so that will be the FCA's objective, is to provide clarity in terms of the meaning of those 17 selected wordings. Now, FCA also noted here that we should bear in mind that policyholders should not assume that simply inclusion of those policy wordings will mean that the policies are responsive. So there are some reservations here, understandably, and the FCA said that they are seeking a judgment that will help policyholders and insurers in terms of understanding the business interruption insurance, and they believe that those 17 wordings are representative of the key arguable issues. So how this will affect insurers who are not participating directly in the test case, because there are a number of insurers who are participating and they are named as the defendants in the FCA test case, but there are many more insurers whose wordings would be questioned. And so how those will be affected, the FCA said that they will be affected as well. So therefore, it doesn't mean that only those who named as defendants in this case, they are bound by the court decision. So, and then the FCA said that in early July, we expect to publish a comprehensive list of other insurers and many other business interruption policies in the market that we expect the test case to affect. I checked it this morning. That has not been published on the FCA website yet, but this is something that we need to keep an eye on. Now, okay, so the business interruption insurance, the test case and all, why do we need to discuss all of these? What is the meaning of this? What is business interruption insurance? So the purpose of the business interruption insurance is to return to the assured the amount of the profit that the assured would have earned had there been no interruption to the business. So that the business interruption insurance may be taken out as a separate policy to the property insurance, or it may be added to the property insurance. So there are several different ways of purchasing business interruption insurance, and there are several different wordings of insuring business interruption insurance. And we see that at least 17 of them now are being tested. So it's just so many different variations are there. What is this business interruption insurance covers? Essentially, business income is the most obvious. So net profits that the assured would have earned absent the suspension of operations. Extra expense could be insured, or contingent business income. For instance, you're a business and then you're relying on a supplier, and there is a problem on the key supplier side, so that the losses follow that might be insured under the business income, contingent business income and extra expense insurance. Civil authority decisions, this is obviously very much at stake when we talk about the coronavirus outbreak, and because it is about an interruption of the insurer's business when authorities prohibit access to the insurer's property. And similar to that, ingress egress, maybe more like seen in the USA, is that an interruption of the business when physical access to the premises is physically hindered by property damage resulting from a covered cause of loss. There are a number of different cases discussing a number of different issues. I'm going to go through those cases one by one as much as the time today allows me to do that. But bear in mind, there are many more cases. Some of them I included in the slides for your reference. Some of them I'm going to talk about, but bear in mind that those cases there, they refer to some other cases. So this is an area actually which has not been really investigated deeply so far, I would say, maybe at least in the literature. But when you do a bit of research, you see that actually there are a number of cases on this. And those cases, when you read them, what are the issues that you would figure out, at least the legal issues that one needs to bear in mind in terms of understanding whether one type of policy wording would cover the loss claimed by the assured or not. The key matter seems to be causation. And the FCA also expressly stated in their briefings and their framework agreement with the insurers that causation is the area that they also seek clarification for. And with my presentation, I will try to shed some lights on this causation matter. And so causation is this overarching issue, which also is the key issue. And moreover, then one needs to consider what are the insured perils under the BI cover, what is the trigger for the BI cover. And with respect to the property insurance, where the business interruption loss is insured, only if that follows a physical damage to the property, then there are questions of what does damage to the property mean. And there are some other triggers for business interruption losses: diseases, notifiable diseases, and civil authority decisions, as mentioned before. Now, in terms of when it comes to the physical damage to a property, then one has to prove that, first of all, the property has to be damaged or lost because of a peril insured against, and then the business has to be interrupted because of that physical damage or following that physical damage. So the proximate cause here is how you prove what caused the loss, basically here, what caused the physical loss. The rules are actually well established in a way that the loss has to be caused by an insured peril proximately. It's the proximate causation rule. And what does proximate cause mean? That means the most efficient cause. It doesn't mean that if there are a few different causes, it doesn't mean that it is the last cause in the chain. It could be the last cause, or it could be the first cause in the chain. What matters is to determine what is the dominant cause there, what is the most effective cause. Some judges suggest that what is the direct cause. So that, how do we determine what is the proximate cause, or what is the most effective cause or efficient cause? Then the judges say that it is a matter of common sense to decide what is the most effective cause. We will come back to this towards the end of my presentation. I just put here a sample clause, which the meaning of which is quite clear. If we look at this here, for instance, we will insure you against loss of earnings in consequence of interruption to your business that commences during the period of insurance as a result of damage to property used by you at the business premises occurring during the period of insurance. This is a clear wording. So I would be surprised if there is anything to dispute here, except for what does the damage to property mean? And especially in the United States, there have been really some creative arguments in terms of explaining or the scope of damage to property, and we will come back to that. Now, physical damage to property. So here, if you look at this slide, that where a policy wording says that we will insure your business interruption losses if there is a damage to the insured property, and if the business interruption loss follows that. So here I highlighted the word to, because it makes a huge difference whether you say, for instance, damage to or loss of the insured property. So, example, this is a case from Australia. So where the business interruption insurance was required to be caused by a physical damage to the insured property. So this is an insurance of a tavern, and there was an argument, some sort of maybe violent arguments that took place in the tavern, and then that was closed for a few hours, and some windows were damaged, and then the windows were repaired in a short period of time. But then later, the tavern suffered loss because the customers, they hesitated to go there for some period of time. And when a business interruption claim was made against the insurers rejected that, because they said that the cause of the business interruption loss was not a physical damage to the insured property. There was a physical damage which was repaired within a few hours. It was simply in the form of breaking the windows. But then the main cause for the business interruption was the loss of reputation. That was not insured against, and therefore the business interruption claim was not successful. Now, in terms of explaining the physical loss or physical damage to the property, then I'm going to mention here two tort law cases, actually. These are not insurance cases, but they are quite illustrative in terms of explaining the meaning of physical loss or physical damage to the property. So in Merlin versus British Nuclear Fuels case, here the claimant was someone who purchased a house, and then everything was well. Then he lived there with his family for some time. There was no problem. But then there was a problem when some radioactive materials were discharged and into the Irish Sea, and then that subsequently reached the area that the house was in. And then there were these radioactive materials present inside the house, but that wasn't visible. And the assured sold the property and claimed damages from the relevant institutions who were responsible to ensure that this sort of damage would not occur in that area. And the physical damage to the property was required to be able to seek a compensation for that kind of loss. And the court said that here, only the presence of radioactive material, so inside the property, it actually resulted in the house being rendered less valuable, but such contamination increased risk to the health of the occupants, but it was not a material damage to the property. So yes, if they hadn't sold the house, if they had still lived in the house, then they might have then later been diagnosed with some sort of illness, but it was a risk to personal well-being, not a damage to the property. So then policy wordings, as we all know, that they are technical, and then we approach to the reading of them technically. And then here, actually in the tort law context also, that physical damage to property was read in that technical meaning and context. And in Blue Circle case, it's a bit different to that. And the difference is here is that here, what we are talking about is an estate, again, which, however, as different to the previous case, was subject to some cleaning up operation physically. Some operations were carried out to clean up the pollution caused by an overflow from the atomic weapons establishment nearby. So there was some physical contamination there, which required some physical actions to be taken to clean that overflow or that damage to the property. Therefore, in this case, for instance, the claim was successful against relevant institutions for the damage caused. So this case is a shipping case. I'm going to mention very briefly, I just need to note here that in the slides that I put more information than perhaps I'm telling you now, or you may not be able to read them all and then at the same time listen to me. So I deliberately put detailed information there for you in case you read the slides later, so the slides will be informative for you. So then in the Ozlem cases, that then we are talking about a ship carrying some materials that can leak from the containers, and indeed the leakage occurred, and that leakage had to be decontaminated. And here the court referred to a criminal case to explain the physical injury to the subject matter insured. So as you can see that here we are talking about insurance matters, but we are seeing that actually in terms of explaining the meaning of physical injury, that a number of cases from a number of different areas of law are referred to. And the court said that the relevant considerations here is, had there been injury impairing value and usefulness of the property in question, and the need for work and the expenditure of money to restore the property to its former usable condition. So that was required, those two were required to accept that there was a physical damage here. And indeed, in this case, the court accepted that. So the wordings are varied, and sometimes we see the wording of physical loss of or damage to property. Sometimes we read physical loss or damage to the property. So they all actually are interpreted differently depending on the wording. So just one word, to or of, they may mean different things, and then actually they may cost the entire insured amount to the assured or the insurer may have to compensate the assured fully just because of one word, and then how we read that. So if we compare the words loss and damage, loss has a broader meaning than damage. So the cases establish this well. So the word loss implies that the insured subject matter has disappeared or is otherwise unavailable for use by the assured. The word damage implies some form of physical change to the insured subject matter, but not necessarily seizure or destruction. That is the case whether the policy refers to physical damage or just damage. Now, some cases will explain really well the difference here that I just highlighted. For that, we need to go to New Zealand, and a case, Crowell versus the Earthquake Commission, was decided by the courts in New Zealand, but it illustrates really well how loss of and loss to, or physical loss to the property matters. So in this case, then we know that New Zealand suffered huge losses because of reoccurring earthquakes some years ago. Now, the claimant in this case lived in an area where all the other houses, they suffered physical damages, but her house did not suffer that. Nevertheless, it wasn't safe to live there, and she was asked to leave the house, and then she had to, and then subsequently it became clear that there was no hope of going back to that area, to that house, and had to buy another house to live in, and lost that house, lost the use of that house. But the house was not physically damaged. Made a claim against the insurers. But the policy wording said that risk insured against was physical loss or damage to the property. And the court said that conceptually, the word loss is broad enough to cover the assured's loss of use, of the ability to use the property. But the act, the relevant act, and the to be able to make a claim against the Earthquake Commission and the insurance policy, they all said loss to the property. So what the assured in this context, in this case, as different to her neighbours, suffered was loss of the use. The property did not suffer damage. So therefore, physical loss or damage to the property, that did not occur. Now, after that, take a look at this clause, please, and try to see whether we can read this any differently, because this is a sample wording that I took from a court case. So this is at the moment considered by the court. So as far as I know, has not been decided yet, but I can see a lot of arguments here in favor of the assured. So the business interruption is a wording that covers this: loss resulting from interruption of or interference with the business carried on by the insured at the premises in consequence of an event to property used by the insured. Definition of event: accidental loss or destruction of or damage to property. Now, here the wording is different from the Crowell case that I mentioned before, because here it says loss or destruction of or damage to property. So the word loss of here makes a huge difference. Here, loss of covers broader or provides broader coverage than damage to. So this case, therefore, actually covers loss of use, which the Crowell case said the policy did not. Now a case from the United States. So this was decided this month, so very recent. And I mentioned before that this physical the physical loss to the property or damage to property, that sort of wording sort of led to some very creative arguments in the United States. And if I can summarize that the main argument basically, because damage to property is very clear as the case is established, then the argument has been that, okay, if you're a restaurant owner, for instance, we had to close the restaurant and we needed to clean the restaurant thoroughly. So basically what we did was that to clean some physical infections there, or some physical effects there. So therefore the existence or the threat of the virus itself was a physical issue that we had to deal with. So therefore our claim for business interruption, because we had to close the restaurant and then we suffered loss of profit, this should be covered by the policy, which insured against the physical loss to the property or physical damage to the property. In this case, which is a decision from Michigan, but it is believed to actually have a wider effect. And there is also a case similar to this decided in New York I'm going to talk about as well. They all are going to one direction. That direction is that direct physical loss or damage had to be something tangible with material existence. This is exactly in line with the UK, the cases from Australia, the UK and New Zealand that I mentioned before. So that requires something tangible with material existence and something that alters the physical integrity of the property. That is very clear. So perhaps because this issue is as clear as that, the Financial Conduct Authority said that those 17 sample wordings that they chose, that didn't include this sort of wording. Although if you read those wordings one by one, because some of them are quite long clauses, they somehow include physical damage issue in the wording as well as some others. But the FCA says that the others, they are actually going to be tested by the court. But the court may clarify or just may comment on the physical damage matter as well. But basically that is not the FCA's objective to clarify this physical damage to property issue, because it's been already clarified by a number of court cases, including recent cases from the United States. So the judge rejected the assured's claim here. So because the hearing was a virtual hearing, and that was recorded, and actually it was posted on YouTube. I just included here the YouTube link, and if you go and then start watching it from minute 23, you will hear how the judge and the reasons of the judge for rejecting the assured's claim here. Social Life magazine versus Sentinel Insurance is also a very recent development from New York. And here we are talking about a magazine, again, had to be closed the premises where they were active. And then they said, well, we are unable to publish magazines. We immediately need an urgent payment from the insurers. Otherwise, we won't be able to print the next issue and we will go bankrupt. So the judge again rejected the claim because they said, well, you closed the premises where you actually print your magazine, but your policy requires physical damage to the property, but there is no physical damage here, so therefore your your claim has to be rejected. So here is an interesting conversation between the assured counsel and the judge, and I think this really summarized the position really well. So that the assured said that, well, the virus exists everywhere. The judge said it damages lungs, it doesn't damage printing presses. The assured said in this case, the virus when it lands on something and you touch, you could die from it. And the judge said, well, you're describing potential injury to a person rather than damage to property. I guess then, these lines must sound now familiar to you, that we already referred to the cases from the UK in this the same line. And the judge said that you get an A for effort, you get a gold star for creativity, but this is just not what is covered under these insurance policies. And that was the final word by the judge. So, and this was again a telephone, this occurred with a telephone conversation. So then it was not published on YouTube, but there were some detailed commentaries on this from the United States. And in this case, applied a case Roundabout Theatre versus Continental Casualty, which was decided in 1970s, where the theatre had to be closed because of a collapse of a building nearby. And the local authorities, they closed the street and the theatre could not operate for about 31 shows they were scheduled. And when there was a claim for business interruption which required closure of the street because of the physical damage to the property, but the property, insured property, was not physically damaged. That wasn't the cause of the closure. That was the civil authorities' decision that wasn't insured against. So then that again, that was applied in the Social Life magazine case. Now, when we look at the now physical damage to property, loss of or loss to the property, they seem to be, at least some of them seem to be quite clear, although loss of is to be tested by the English courts, as I mentioned the policy wordings before. Now, infectious diseases. There are several different wordings. By just a quick look at the FCA test case will show that. And now we can just see, when we look at those policy wordings, does this policy wording cover losses caused by any infectious disease, or in respect of a defined list of infectious diseases, or in respect of notifiable infectious diseases? So as we all know, that COVID-19 was made a notifiable disease in England on the 5th of March 2020. And I don't know if you heard about this case before, New World Harbourview Hotel versus ACE Insurance. This is a hotel in Hong Kong and made a claim for business interruption after the SARS, which occurred in 2004. And you can see that actually here, the assured was successful because of the policy wording. Because the policy wording said, if you look at simply just the last 3 lines, or 4 lines, so it actually provided cover for closure by a competent authority due to several number of issues occurring within 25 miles of the premises. So this kind of policy wording should also help with respect to COVID-19 claims, should help the assured. Non-damage cover for denial of access to premises. Again, this is very much common for the assured who are making a claim against the insurers these days. And they typically require mandatory closure of premises by law enforcement or government agencies exercising statutory powers as a result of certain defined infectious diseases. So the issue seem to be focusing on here is whether the definition provided in the contract that can be read in a way including coronavirus. And that entirely depends on what sort of wording is chosen there, whether the policy said any, or whether the policy said just here are the list of the diseases that we provide cover for. For instance, this is again an old case in which this sort of wording, non-damage, cover for denial of access, that was accepted. And this is a case from the United States. So the assured suffered business losses because of a curfew. And curfew was because of the riots occurring at the time. And the policy wording said, this policy is extended to include the actual loss, not exceeding 2 consecutive weeks, when access to the premises is prohibited by order of civil authority. Clear wording, matching with the facts, and there was a coverage under this insurance contract. The biggest question seems to be, and I believe that this would be discussed by the Financial Conduct Authority, but we will yet wait and see to what extent they will touch upon this. But with the coronavirus outbreak, the main question is this. We have the virus outbreak and we have the government's instructions to close the businesses. Now, what caused the loss? Was it the virus? Was it the infection? Or was it the threat of it? Or was it the government's decision? Which one caused the loss? Now, we need to determine the most efficient cause. So because the proximate cause is determined by identifying one cause amongst maybe many as the most efficient cause. How do we determine which cause is the most efficient? We used common sense. So how do we use that common sense? Is there any test in this regard? No, there aren't any tests in this regard. So then is this the judge-made law? Now, some judges say no. It is simply what the parties agreed. And what the judges do is to interpret what the parties agreed. So therefore they say, this is not a judge-made law. This is what the parties agreed. The answer lies in the facts, they say. So therefore, the answer depends on how we read the facts. So with the coronavirus then, the question is this: what actually caused the loss? And I identified these questions by looking into the marine insurance cases. They seem to be a really good guidance in this respect. And the key issue here is separating two matters. Was the loss caused by avoiding a peril upon a mere fear of it, or whether it is caused by evading a risk that was immediate, present, and that has begun to operate? So if it is the first one, there is no coverage because it's simply avoiding a peril upon a mere fear of it. If it is the latter, because the risk has begun to operate, there is coverage there because the risk began to operate. So there are a number of cases in this regard. I'm going to talk about a few of them briefly. I'm conscious of time. Now, the Sunday case, the First World War and the declaration of war between Germany and the United Kingdom, and the ship which was sailing towards Hamburg, the voyage was abandoned and should sail to the UK, and then made a claim against the insurers for constructive total loss. The question was this: what caused the assured loss here? Was it His Majesty's declaration of war, or was it the law which is saying that now you can't trade with Germany anymore? So the first one, the outbreak of the war, was an insured peril, but the implications of the law, the legal issues followed by that declaration, that wasn't an insured risk. So therefore you can then imagine what the insurers argued and what the assured argued. And the court here decided for the assured and then said that here, although in a sense the loss came from both of these issues, both causes, the proximate cause was the former. The act of the sovereign in declaring war and the calling of the common law into operation were inseparable. They formed two parts of one single exercise of the royal prerogative. And in this respect, I put two decisions here. You can see them. I'm sorry that I forgot to put the reference for fidelity, but if you go to Westlaw, then you will find that it's a Privy Council decision. And these two decisions are also quite difficult to reconcile. I'm going to refer to this wording a bit later. I'm going to say that one case was distinguished from another without a difference. I believe that fidelity and Jason, they were also distinguished without a difference. But I don't have time to go through that. But if you are really interested in this, take a look at that, and you can see that actually there is, you can see why I am arguing that this is a distinguishing without a difference, but you may or may not agree with me. And there is another case, the Becker case, to confer with the Sunday case, which was decided for the assured. Again, the First World War. Again, a ship which abandoned, abandoned the voyage again. And the court here, however, decided differently, because the court said that in the Sunday case, the ship was British, the ship captain was British, they had no options but to obey the rules. But here, there was no question that the parties involved, a German ship, then didn't have to comply with the rules that came into force after the war. So therefore, yes, the master deviated from the voyage, but it was the master was self-restrained. So they basically distinguished Sunday on the basis of the nationality of the ship and the master. And they said here, it wasn't the war, but it was the master's self-restraining then that caused the loss, and the assured lost the claim. Now, two more conflicting decisions coming towards the end of my presentation is that the Knight of St. Michael and I guess this is read as Kasyanov, maybe, the case, the two different cases, again, can they be reconciled? The Knight of St. Michael, briefly, shipment of cargo or coal in Australia, and soon after the ship started sailing towards destination, the cargo was heated, and the cargo, some of the cargo needed to be discharged. Otherwise, then the ship would be burned. And those cargo that heated was discharged at an intermediate port, again in Australia. And the ship then sailed towards destination and then delivered the rest of the cargo. And the ship owner lost some of the freight in proportion to the one those coals that they were discharging in the intermediate port, because the freight was to be paid on the basis of the cargo carried and then delivered. And when the assured claimed the shortage of the freight from the insurers, the court accepted that claim because the court said that here the peril began to operate. But then if you look at the Kasyanov case, the ship was loading the cargo, and at that moment, the war broke out, and the insurer said that if you sail, and if this ship was captured by the Japanese forces, we will not cover you. And the assured abandoned the voyage, made a claim for a constructive total loss, and the insurer said, well, here we distinguished the Knight of St. Michael. Here, the peril did not begin to operate yet, and the Knight of St. Michael is a case decided difficult on very difficult facts, so we distinguish that. This is exactly the same reason which Jason distinguished fidelity. They said it was a difficult case and decided on difficult facts, we distinguish it. A similar reason for distinguishing here and Kasyanov. And in Kasyanov, actually, then you can think of, okay, then if the peril did not begin to operate here, how far then it had to go to be able to say that actually it has begun to operate. And the court said that actually then if the ship had sailed, and then if there was then a risk of Japanese forces there, and then so clear they were about to capture the ship, or if they captured the ship, it would have been different. Well, I mean, then did the master have any options there, or the assured there, because the peril is clearly there, the Japanese forces would capture. The insurer said we are not going to cover. Nevertheless, the court rejected the assurer's claim and distinguished the Santos, the Knight of St. Michael. But I think this is a distinction without a difference. Now, where are we? It's the causation, the matter, the clear, the answer lies there. And the rules to determine causation, what caused the loss, basically is Leyland shipping case, which was decided, again, because of a World War I, the loss of the ship during the World War I, then the Leyland shipping case changed the rule until Leyland shipping. Then the rule was that the last cause in time, the one closest to the loss, was the proximate cause. But Leyland shipping then changed the rule and said, no, that's not the rule. We look at proximate in time. Sorry, we look at proximate in efficiency, not proximate in time. So did this make the job any easier to determine what caused the loss? That made it more unpredictable and less certain, because what is the most efficient cause? This is basically, the judges said, you use your common sense. And you see that when you use the common sense, in every single case, the outcome is different. You can't predict it. And the judges say that the question to be asked about is, if you are from the assurer's perspective, did the risk that I paid the premium for occur? From the insurer's perspective, did the risk that I collected the premium for occur? So that therefore you look at what the parties intended by putting that wording in the contract. So this is then an interpretation of the insurance contract wording. Again, an area that is entirely unpredictable. So, but there are some certain issues, such as the definition of damage, physical damage, that required changed physical state. We are certain of that. Loss, again, is likely to be interpreted more broadly than damage. So therefore, you can clearly contrast, compare loss of use wording and loss to property wording. Notifiable diseases, we all will see how those wordings will be read by the by the courts. And by the way, the FCA and the insurers, they entered into a framework agreement before they brought the case to the court, and they left open the opportunity to appeal the case. So it's likely that it will be a leapfrog appeal, and then it will go to the Supreme Court for further clarification. And the answer lies in the facts, but then how actually the judges will decide, as I said, is very unpredictable, and at the same time is quite interesting, and we will all wait and see. Thanks very much for your interest. So I will stop sharing the screen now.
Thank you very much for that. For those who are watching and listening, the citation for the Fidelity and Casualty case has been posted into the chat box and will also be included in the follow-up slides. If anyone has any other questions, please do feel free to unmute yourself or put those into the chat or Q&A box. But otherwise, one question that has come in is, it was explained that the measure of loss is the profit which would have been earned had it not been for the insured business interruption event. But if the court finds that approximate cause is deemed to be an insured event, which causes a specific business closure, but in circumstances where, say, social distancing controls or travel restrictions have been introduced more generally, might it be the case that the business would not have had any customers in any event, even had they been open, and therefore wouldn't have made any profit, even in the absence of the insured risk? So the policy might actually respond, but the recoverable loss would be nil.
Right. I wouldn't do that separation, because or that link actually, because what you need to look at is basically what caused the loss. So certainly the assured suffered loss of profit. So that loss of profit will be calculated on the basis of what the policy provided. So that this amount is deductible, we will pay 2 weeks of your loss or maximum 3 months of your loss, and this is the policy limit. So you are entitled that amount so long as you prove that one of the insured risks caused the loss. So therefore, in your case, actually, is not that the assured's loss is nil, my interpretation. The assured's loss is whatever the assured loss actually suffered. But the key issue here is whether the social distancing rules, or whether, if, for instance, the civil authority is to close the businesses, whether that caused the loss, if it is an insured risk. So therefore, the answer here is which one caused the loss, which one was the most efficient cause. So the court may say that the loss was caused approximately, directly, most efficiently by the instructions to close, or may say most efficiently by the social distancing rules. So, but you can never know which one actually the court will decide, because you could argue either way. So therefore, unless you sit down and settle the claim with the assured, then you are bound by what the court will say. But what the court will decide, I think, in my understanding and reading, is not that the assured didn't suffer any loss, nil, suffered loss, but which one is the most efficient cause. The court may say that, exactly as you said, the loss would have occurred anyway because of the social distancing rules, but then that would make the most efficient cause the social distancing rules. But if the civil authority's decisions is an insured event, then the civil authority's decisions caused the closure as well as the social distancing rules. So therefore, you can say that was an overarching causation, and that is the most proximate, the most direct cause of it. So the answer is, what is the most efficient cause? I think one judge said that I used the word direct, because the judge said that Lord Dunedin said that in one of those cases, the Becker case that I referred to. He said that I prefer to use the word direct, because when you think about the proximate cause, then what you mean is actually the opposite, is the remote cause. So therefore, you can think of it this way: the remoter the cause is, the less the chance that the insurance contract would cover for that risk. So therefore, which one is the direct cause? That is what I think we will look at.
Thank you. And another question we've had, looking forwards, if you will. Do you think that there will be specific COVID-19 exclusion clauses in business interruption policies, or will insurers rely on definitions of, say, unforeseen event to argue that COVID-19 is now entirely foreseeable and may remain so for some time?
It's again, whether or not there's going to be an exception, my reading is that several different documents, that it's going to that direction. So the insurers will try to include exceptions, either maybe expressly COVID-19 exception, or perhaps they would say unforeseen viruses or outbreaks, they will be excluded. So this will be entirely, again, the interpretation of the contract. So no matter how certain we try to be in an insurance contract, we are bound to lose, because you can't really list every single risks that will be insured against or that will be excluded, because what you are doing is that you are insuring against something that may occur in the future, that may not occur in the future. So we can't really predict the future. We try to do that, But then, because it's not possible to list every single item that either might or might not be covered by the insurance or excluded by it, then we might include some general wordings there. But then the more general you go into, then, okay, then how are you going to interpret that? One chance is that that general wording is so broad that that would cover pretty much anything and everything. Or you might just list a few items, and then you may say that this either is exhaustive or not exhaustive, and then we also mean to exclude, or we also mean to include, whatever you would like to, this sort of and that type of risk. So yes, my impression is that there will be exclusions. The wordings probably will vary from policy to policy, depending on the broker's also power to negotiate the terms there, and also depending on the FCA test case.
Thank you very much indeed. I think that brings us just inside of the hour. There's no more questions coming up on the Q&A. So if anyone else wants to chime in with any more questions, please do so now. Otherwise, on behalf of all of the attendees in Bristol Law Society, thank you very much for joining us today, and enjoy the rest of your afternoon.
Thanks very much for your interest. Thank you for giving me this opportunity as well. I hope that it has been informative. Thanks.